and welcome to another ABI podcast. I'm Amy Quackenboss, the Deputy Executive Director of the American Bankruptcy Institute. Today I'm joined by Chris Ward and Ryan Foley, who co-authored ABI's newest publication entitled A Business Creditor's Guide to Distressed Vendors, Debt Collection, and Bankruptcy. Our podcast will explore this book and its importance for bankruptcy practitioners. By way of introduction, Chris chairs Polsinelli PC's bankruptcy and financial restructuring practice and is a managing shareholder of the firm's Wilmington, Delaware office. He focused his practice on corporate bankruptcy, financial restructuring, bankruptcy litigation, and distressed asset sales, as well as non-bankruptcy alternatives, and has represented numerous Chapter 11 debtors and unsecured creditors committees. Chris is a member of ABI's Board of Directors, as well as Polsinelli's Board of Directors. Along with many other industry awards, Chris has been listed in the Best Lawyers in America for Bankruptcy and Restructuring in Delaware since 2015. Chris also is an editor and contributor to the app version of Polsinelli's The Devil's Dictionary of Bankruptcy Terms, which is available for free on iTunes. He was also the editor and an author of ABI's publication entitled The Chief Restructuring Officer's Guide to Bankruptcy. Chris's co-author, Ryan, is a partner at Shook, Hardy & Bacon, where he co-chairs the firm's Bankruptcy and Creditors' Rights Practice Group and represents secured and unsecured creditors, lessors, lessees, and investors in issues related to bankruptcy, insolvency, and debt restructuring. He has represented Chapter 7 trustees in avoidance actions and handles a variety of consumer litigation matters, including claims relating to the Fair Debt Collection Practices Act, the Fair Credit Reporting Act, and various other state consumer protection statutes. He is a registered mediator with the U.S. Bankruptcy Court for the District of Delaware and is board certified in creditors' rights law by the American Board of Certification. Ryan has been a presenter on bankruptcy topics and is a frequent writer, having been published numerous times in the ABI Journal and elsewhere. And earlier this month, Ryan was named ABI's 2017 40 Under 40 honoree. Welcome, Chris and Ryan, and thanks so much for joining us today.
Thank you, Amy.
Thank you for having us, Amy.
So this new book is a great addition to the ABI library. Can you tell the listeners how the book came about and who is your intended audience?
Amy, this is Chris. I think that the book came about because this area of the law is a burgeoning area. It's something that's been out there for quite a long time, dealing with distressed investors. But I think in recent times we've seen more Chapter 11 bankruptcies where distressed investors are turning to bankruptcy in order to cure their insolvency needs. So it's something that Ryan and I discussed and thought it would be best to get in front of general counsel, credit managers, CFOs, attorneys, or just plain lay business people in order to prepare them for bankruptcy and to pre-plan for the avoidance of these issues in the future.
And that's exactly the theme and message of your book seems to be prepared. So what are some of the warning signs that a credit manager can look for in a vendor to determine whether the vendor is entering into distress and may have issues?
I think a primary thing that, this is Ryan, by the way, I think a primary thing that comes up, Amy, is, when you have a long-term relationship with a customer, if you will, or a client, and they've been usually very good payers within reasonable terms, the 30, 45-day window, and then all of a sudden, the payments get a little bit later. There's a phone call to the salesperson they've been working with, or to a credit manager asking for an extension of time, and and then it just it's like snowball after that. It just snowballs, and the balances get bigger, the months go by, and at the end of the day, because there's a relationship, people kind of let it go a little bit. I think particularly the salespeople kind of let it go a little bit in order to keep the business. But that's definitely just one example of red flags, like the extension of what ends up being credit when you didn't intend to extend credit of outstanding balances. That's one red flag I think that comes up fairly frequently.
And Amy, this is Chris. I completely agree with Ryan. I think constant vigilance is the term to use here. You have to follow the AR, and if the AR starts to grow, you have to get out in front of it, because once it grows to 90, 120 days, it's too late at that point. So you need to be vigilant about following the AR of your company.
And so your book, is very comprehensive about some pre-planning tools that businesses can use to protect themselves against those distressed investors who find themselves, using more credit. And the first one you mentioned is effective debt collection. But of course, as we all know recently, that comes with its own traps and pitfalls for a business trying to stay in line with, of course, the Fair Debt Collection Practices Act. Can you all address this in your book, but can you briefly discuss the statute and some of the things that business managers should do to avoid on the receiving end of FDCPA enforcement actions?
Sure. This is Ryan. I think one thing to keep in mind is the Fair Debt Collection Practices Act, FDCPA, for sake of brevity, is a statute that only applies to third-party debt collectors. So some of our intended audience, as Chris kind of highlighted before, general counsels, chief litigation officers, credit managers, etc. If you're collecting your own debt, and let me specify that the FDCPA is applicable to consumer debt collection only. But if you're collecting your own debt, the FDCPA is not going to apply to you. Now, there has been there's certainly case law out there where plaintiff consumer attorneys have tried to kind of spread that out, where a subsidiary that's collecting on behalf of a parent company falls into the third party category, if you will, and therefore they're liable under the FDCPA. But primarily it's when the situation of the FDCPA arrives when the corporation sends the debt out to a collection agency or a law firm. Now, that collection agency or law firm is now a third-party debt collector. Therefore, when they go to collect consumer debt, the FDCPA applies to them. So they have to be the ones that are responsible under the FDCPA, the law firm, the collection agency. What a general counsel or business people or credit managers have to be wary of is, who are you sending your debt to? What kind of diligence have you done to investigate that your third party that's collecting your debt is above board with respect to its collection activities? Are they following the FDCPA? Are they bonded? Are they a part of the various trade associations that in the creditors' rights or universe, that they're all connected to that, so that therefore they're doing what's best? Because at the end of the day, even though you're kind of outsourcing that collection activity, your company's name is still going to be on that paper. If it gets to a demand letter or if it gets to a complaint, that's going to be your name. Now, the FDCPA might not circle back up to you because, again, it's third-party specific, but it's also good. Your name's going to be out there, so there's definitely commercial damage that could happen if that third party is not handling the debt collection appropriately. There's also occasions where the corporation will be named in an FDCPA lawsuit, a consumer kind of plaintiff action, but very quickly can be removed from that. But I think it's more just to know about that statute, understand its ramifications, and it's really a guide to who's collecting my debt and are they above board with everything they're doing. I think that's an important takeaway when it comes to the FDCPA.
Those are really important points. And similarly, the book talks about the Fair Credit Reporting Act and, of course, credit reports and how useful they can be to assess offenders' financial health. But why must business creditors really pay attention to the Fair Credit Reporting Act?
This is Ryan. I think part of it is what you want to make sure you're doing is you could really have if the report that the credit report you're using is misused in any fashion by people on your team that might be doing the debt collection or managing the outside firms or agencies that are handling debt collection. If it's misused in any way and reported incorrectly, you could have a big problem. I mean, you could have a big problem with damaging someone's credit. And if you're doing that, that's going to make it hard for that person to get loans and do various things they want to do in their lives. And I think that you must be mindful of the impact of how you're handling that. And the way to do that is by having the appropriate procedures built internally to manage, how are we, all right, so we're going to run the fair, we're going to get our credit report, and then what are we going to do with it? Well, here's the steps that you created internally. Here's the guidelines, if you will, for how you go about using that credit report on that individual. Because if you run afoul of that, you could have some significant impact on that person's credit. Also, then that's going to get turned around, and then you're going to get sued by a plaintiff's consumer attorney and cause all sorts of unnecessary legal expense for yourself. And if you're a big company that uses that, take a credit card company, if you will, if you use tons of credit reports on a daily basis, and there's a bad egg utilizing those credit reports, ultimately you could be looking at a class action lawsuit that then all of a sudden, not only you're defending that, you're spending millions of dollars on attorney fees, but your name's getting dragged through the mud in all the papers because of what happened with the use of the credit report. And that's why I think the takeaway there is to really have strong internal guidelines built and discipline when utilizing any kind of credit report.
I think those are all really good points, and I like the fact that your book goes into the Fair Credit Reporting Act and the FDCPA, and talks about those, because a lot of books that are guiding general counsel, they just kind of say, well, this is the collection process, this is how you litigate, and these are all important things, practical things that credit managers and folks collecting debt really need to know about. So there's a lot more of that in the book. You also mentioned in the book the Consumer Financial Protection Bureau, which is the primary enforcer of violations of consumer finance protection laws. A couple questions that I have about that, and I think you address in the book, but do all business creditors need to worry about the CFPB, and what are the issues that the CFPB is most concerned about that we're seeing in enforcement actions these days? And can you briefly describe the process for the CFPB to bring an action against a creditor?
Yeah, I mean, the CFPB is in today's world is very interesting, and it's getting some headlines recently. And if anyone has seen that with respect to the kind of the new leadership at the CFPB, and it's and I'm stuttering because I'm just thinking, I'm somewhat smiling thinking about it. It's just very strange that how the political winds shift. All of a sudden, the relevancy of the CFPB is somewhat in flux. I think from 2012 till maybe slightly before that, at the tail end of the economic crisis that began in 2008, I think the CFPB was a very powerful entity. Elizabeth Warren was one of the first, was the creator of it, and then passed it on to the gentleman's name escapes me right now, but who just recently left his post. They were enforcing, a lot of it was, treatment of, back in that time frame, 2012, 13, even before that, it was about, payday lending, how the mortgage industry was going about its business, mortgage servicing, sale of mortgages. They kind of turned their spotlight on collection agencies and how they went about and leveled significant fines on the collection agency industry. Several millions of dollars were levied in fines by the CFPB, and then so that was kind of like, I think, at its height. And now it's I got to be honest, I don't know what the next, call it 3 years or so at least, are going to be for the CFPB with the changing of the guard, how relevant and how powerful of a body of enforcement body it's going to be. But I think to kind of answer your point is I think all business creditors should worry about it still, because it is a live, active regulatory agency of the federal government. And if kind of going to the Fair Credit Reporting Act, if you don't have a disciplined internal process for how you manage your collection activities or your servicing activities, if you're servicing mortgages, et cetera, you could have some trouble with the CFPB still. I think part of it, what happens is it's not dissimilar, I think, from the initiation of bringing an action against a creditor. I think it starts like anything in any state where you complain to the attorney general about something that happened. There's a hotline, there's an email. If you go to CFPB's website, you can submit a problem that you had with a collection agency or a creditor or some fashion or a bank, and that kind of kicks off the process. And then there's a government worker that will contact that creditor or contact you, that raised the issue and seek additional information, and they'll do their own kind of internal investigation. But there is a limit to what they do. They kind of only focus on the financial services industry. So if you complain about your mechanic put on the wrong wheel or something like that, that's not going to be their area. They're gonna focus on financial services issues. But I definitely think that despite the changing of the political winds, it's definitely something to be mindful of. Just it's not a free for all now. And if you go about your approaching your industry, and if you're in that financial services industry, that it's a CFPB is not going to come back to haunt you, I think you're making a big mistake. And a way to avoid that is just making sure those internal processes of what you're doing are tight. It might make sense to hire former workers at the CFPB and get some consulting opportunities in the door to kind of say, hey, this is what we're doing. Does this make sense? I think, my prior life, I was in-house counsel at a large financial services corporation, and it was during that 2008 till 2000, well, actually the last year, and regulations and regulatory bodies are all over the place all the time in those time frame, and it helped straighten a lot of things out, and I think that the CFPB is still going to be able to do that.
Right. So if you're dealing with consumer debt, you at least have to know what it is and be aware that there are things that you can do to protect yourself.
Absolutely right. Yep.
That's great. And all of those details are in the book. So you guys also talk about contractual protections that business creditors can put into agreements with distressed vendors. Can one of you identify a couple of those types of protections? And are vendors really okay with adding those? Do they have a choice? Is it all part of negotiation?
Yeah, absolutely, Amy. This is Chris. Ryan talked about a lot of the regulatory issues that are out there in trying to collect debt. But as we discussed, planning so you don't have that outstanding balance is the best way to go. Some of the protections you can put into agreements, my two favorite are what I call a springing security interest, and the second one would be putting payments into escrow. A springing security interest would be a situation where you have a contractual obligation. It's on an unsecured basis, but you build into your agreement up front that if any payment is late or if payments fall 90 days behind, that the company can file a security interest against the vendor for those amounts due, and then have a security interest in the goods. What we've done sometimes is actually have the security interest attached to those vendor agreements and then leave the right to perfect that security interest in the agreement only if there's a default or if payments fall X days behind, which would equal a default. So the security interest springs at a later date. It's not upfront, so it's not a secured credit that you're offering. It's unsecured credit with the ability to provide a security interest down the road if there's a default under the agreement.
Right, and you probably want a pretty tight leash on that, because if they get too far out and they file bankruptcy, you're not able to perfect those security interests, right? So you want to pay attention to those.
Absolutely. And if you filed a security interest in the 90 days preceding a bankruptcy, it would be preferential and avoidable.
Yeah.
So it all goes to constant vigilance and staying on top of the account. Mm-hmm. The other mechanism that we've used a lot recently with our clients is having the payments from the vendor made into escrow, either in advance or even contemporaneously, so that those payments are in escrow, which is outside of a bankruptcy estate. They wouldn't be property of the estate under Section 541 of the Bankruptcy Code, and thus wouldn't be subject to a preferential transfer since they were never property of the estate. Those are just two issues that are addressed in the book, but those are our preferred mechanisms we put into agreements with vendors in order to protect clients. Yes, the vendors push back on those. Absolutely, they push back, and that is, especially on the security interest, one of the reasons that you make it a springing interest at a later date is we're not going to require you to do this now. We're going to give you an agreement. We're going to do it on an unsecured basis, but if you don't live up to your obligations, we have this right to perfect our security interest and have a secured interest, but only if you don't live up to your terms and obligations.
Yeah, so if you're in breach of the agreements, right? Yeah. Mm-hmm.
Absolutely. Payments in the escrow are becoming more common as we see more Chapter 11s, and especially as Chapter 11s are large preference actions and preference runs. Mm-hmm. Vendors understand that payments may have to be made in escrow in order to protect them or to protect clawback. So that's a little more generally acceptable. But vendors are becoming just as sophisticated as well, so they understand the risks involved in this.
Right. I would think that if a vendor refused to make payments into escrow, I guess there maybe is a little bit of additional cost, but that might be a red flag in and of itself.
It absolutely is, and that's a lot of vendors don't like to do that because it is a red flag, and they know that they're dealing with a potentially distressed entity. Yeah. So you have to be very careful when you introduce that.
Yeah, right. Well, of course, when vendors don't pay, then you are going into litigation. And your book talks about some effective pre-litigation strategies that businesses can use to collect their debts from distressed vendors. And can you guys talk about some of those?
Yeah, no, it's Chris again. I jump into one of them is a consent to judgment. If you can have a vendor who knows that it's a straight breach of contract action. They bought $100,000 worth of product. They weren't able to pay for it. It's a clear breach of the contract. Rather than spending the money to litigate the breach of contract, parties will consent to a judgment, which then you can file of record and have out there. So, you might not necessarily come ahead of other creditors if you don't have a right to securitize that judgment, but you have the judgment and you're not going to have to litigate the amount of the claim. And in the bankruptcy, you're going to have an allowed valid claim that is going to put you in a spot that's much better off than in other instances. I think the other pre-litigation strategy is something that we just discussed on the security interest, is really the only way to put yourself ahead of other creditors is to increase the priority of your claim. So something like a springing security interest or even a consent to a secured claim for the value of the goods provided is going to elevate your claim above other general unsecured creditors. It doesn't overcome the valid first perfected security interest in substantially all of the assets, but it does put you in a better position against all other creditors in the case.
Right. Yeah, and when I was practicing, one of the things that really frustrated many of my clients who happen to be credit managers was the preference statute. And, it was kind of like rubbing salt in a wound for them. They were owed hundreds of thousands of dollars, and yet a payment that was made within the 90 days before bankruptcy, they had to give back. And so can you explain the purpose of the preference statute of 547B? And then, do you have any advice to creditors who are facing avoidance actions?
Yeah, no, absolutely. It's Chris again. Fortunately or unfortunately, however you want to look at it, Congress has approved a statute that allows any payment made by a debtor in the 90 days preceding the bankruptcy to be a de facto preferential payment, subject to all the defenses provided in the bankruptcy code. The times that we've been plaintiffs in these cases, we've received the same calls that you just discussed. Is how can you do this? First of all, I don't get paid for any of the amounts owed to me, and now I'm getting sued for the small amount that was paid to me. At the end of the day, the debtor is allowed to do it, but that is why Congress gave the defenses that are out there: the ordinary course of business, new value, contemporaneous exchange for those vendors. The purpose behind having this preferential statute law is it wants to treat all general unsecured creditors equally in that 90-day window leading up to bankruptcy. The person that yells the loudest or threatens the most shouldn't be the creditor that's receiving the lion's share of the debtor's cash going into bankruptcy. So to the extent you are sending dunning letters and demanding payment or threatening to stop shipment without receiving payment, that will be held against you in any preference action that's brought, because you have elevated your claim above claims of other general unsecured creditors. So fair and equitable treatment to all creditors was the purpose. I think the preference statute's morphed in time. The substance of it hasn't changed, but the application of it has. We now see mass preference runs where literally every vendor that received a payment in the 90 days leading up to bankruptcy is sued, whether they clearly have new value defenses or ordinary course of business defenses. So vendors that receive these letters, especially the demand letters before a complaint's filed, need to take a look at them and see if there's defenses that they have prior to a lawsuit being brought. Because once a lawsuit's brought, you're going to have to incur attorney's fees in order to negotiate, file an answer, appear at an initial scheduling conference. Most of the plaintiffs, whether they're Chapter 7 trustees or law firms, are going to send out a demand letter first that's going to offer to settle the claim for X percentage of whatever the face value of the preferential payment was. So if you're able to provide defenses and negotiate with plaintiff's counsel prior to suit being brought, you may be able to settle for something far less than you will when a complaint is brought and you have a settlement that's in that same range, but now you've incurred $5,000 of legal fees on top of it. So I think the advice is don't ignore those letters when they come. Right. They may be demanding 80% of payment, but at the end of the day, negotiation off that letter is going to be far more beneficial to you than having a complaint filed and having to deal with defending that complaint later on.
Right. And also, going along with the theme of your book, probably be prepared. Make sure you have all your records together, because a lot of times the debtors don't have their records, so they, even though they send you a demand, they may not have any timing information about payment or copies of the check or anything. So it's, I think being prepared in that way probably would go along with the theme of your book.
Yep, absolutely.
So your book ends with a detailed discussion of bankruptcy and the bankruptcy process, as well as certain non-bankruptcy alternatives. Is it too late for unsecured creditors to collect on their debts if their vendors get to this point? And what should business creditors do as soon as they get notice of a bankruptcy?
You know what? I think following up on what you just said, Amy, time is of the essence. Be prepared is the answer to really everything in this realm. Bankruptcy moves fast. When a Chapter 11 petition is filed, there's going to be a hearing within 24 or 48 hours. There's going to be a proposed budget filed in the case, whether it's cash collateral, debtor in possession financing, that's going to lay out all the payments the debtors can make. So it's not too late if a bankruptcy is filed, but you do have to be prepared to act quickly. There may be critical vendor status available to you. You're going to want to assure that payment for your goods is accounted for under the budget. You're going to want to make sure that there's no early bar date for either general unsecured claims, administrative claims, or 503b9 claims. Maybe an opportunity to serve on a creditors committee, and then have creditors committee hire counsel and financial advisors, which are paid for by the debtor's estate. But all of this is going to happen, or could happen, within the first 10 to 14 days of a bankruptcy case. So you need to be prepared to react quickly if you do receive a bankruptcy petition. I think it all falls back to, as you said, be prepared.
Yeah, that's all great advice. And I mean, we're almost out of time, but I just wanted to say thank you to both of you for writing the book. I mean, I think it really is a practical guide that business people, not professional, lawyers or financial professionals, but business people will really find helpful. And, perhaps folks might want to give them out as holiday gifts to their clients. So they are available on the ABI.
Rightfully so.
Yeah, that's right. That's right. They're available. The new book can be purchased on the ABI website at abi.org. And Chris and Ryan, you should be very proud of yourself. We appreciate all your hard work. And we know it's not easy writing a book, but you all put the time and effort in. And we appreciate your also coming to the podcast and providing your expert advice on this very important topic.
Thank you very much, Amy, and thank you to the ABI for everything that it does with respect to educating insolvency professionals. It's unbelievable. Thank you.
It's our pleasure.
Yeah, I'm just going to reiterate what Chris said. Thanks, Amy, for the time today. And the ABI is the best resource around for information about the insolvency profession. And without you guys, we wouldn't have the opportunity to put this book together. So thank you very much.
Well, thanks, Ryan. Thank you. From ABI headquarters, thank you for listening and have a great day.